In the last video, we had looked at voluntary lease extensions. Now we're looking at the statutory route. This is where a qualifying leaseholder can compel the landlord to grant a lease extension. But because of recent leasehold reform, you need to understand what has changed now, and what is still waiting to come into force. So for flats, statutory lease extensions are governed by the Leasehold Reform Housing and Urban Development Act 1993. Under the current operative law, a qualifying leaseholder can usually claim an additional 90 years added to the existing lease term, with ground rent reduced to a peppercorn. The Leasehold and Freehold Reform Act 2024 introduced major reforms including 990-year lease extensions and the abolition of marriage value. However, many of those reforms are not yet fully enforced, so practitioners must distinguish between the law currently operational and future reforms still awaiting commencement. So one major reform is already in force. From 31st January 2025, the 2-year ownership requirement was removed. Historically, a leaseholder generally needs to own the flats for 2 years before serving a statutory lease extension claim. That is no longer required. However, the leaseholder must still be able to prove ownership of the leasehold interest, usually through registration at HM Land Registry. So looking at the Section 42 notice, the statutory process begins with the leaseholder serving a Section 42 notice on the competent landlord. This is the formal statutory notice claiming the lease extension. The notice must contain prescribed information which include the details of the leaseholder, the existing lease, the terms being claimed, and the premium being proposed by the tenant. And importantly, the premium inserted into the notice is usually based on valuation advice provided by the leaseholder's specialist surveyor. The surveyor will usually advise on what they believe the premium should be and the opening and negotiation figure to be included within the notice. This is a strategic decision because the premium proposed can significantly influence negotiations moving forward. The Section 42 notice is highly technical, and if it is defective, the claim itself can be put at risk. That is why specialist legal drafting is critical. Then, the landlord responds by serving a Section 45 counter notice. This must state whether the tenant's claim is admitted or disputed, which terms are accepted or rejected, and if entitlement is denied, and the grounds which are relied upon. If the landlord fails to serve a valid Section 45 counter notice within the statutory timeframe, the tenant can then apply to the courts for an order granting the new lease terms proposed in the Section 42 notice. So looking at premium, valuation and costs. The tenant must pay a premium for the new lease. Under the current valuation regime, this may include the landlord's loss of ground rent, the value of the reversion, and where the lease has less than 80 years remaining. Marriage value may still apply until the relevant reforms are commenced. This is why specialist valuation advice is essential. But another critical issue is cost. The statutory route is often significantly more expensive than a voluntary lease extension. This is because the leaseholder is generally responsible not only for their own professional costs, but also for the landlord's reasonable professional costs relating to the statutory claim. So in practice, the leaseholder may need to pay for their own solicitor's fees, their own surveyor's fees, the landlord's solicitor's fees, and the landlord's surveyor valuation fees. Importantly, this usually relates to the landlord's reasonable cost of dealing with the statutory process itself, not cost of tribunal litigation where matters become disputed. So while the statutory route provides legal protection and certainty, it can also involve substantial professional costs. If the premium or terms cannot be agreed, either party may apply to the first-tier tribunal, and the tribunal can determine the premium payable, the lease terms, and other disputed issues arising from the claim. This is one of the strongest protections within the statutory framework, because a landlord cannot simply refuse to negotiate indefinitely. Again, if the flat is mortgaged, the lender's position must also be considered. A statutory lease extension is commonly treated as a surrender and regrant for registration purposes. This means the old leasehold title may close, a new leasehold title is created, and the lender's charge must continue onto the replacement title. So again, a deed of substitution has to be entered into. I hope you guys enjoyed this video just summarizing the statutory route of lease extension. If you have any queries, please do let me know in the comments. And again, this is for educational purposes. I would be grateful if you could please like, comment, and subscribe. Thank you.